Hello everyone, today we are going learn one of the service in capital flow about changes and corrections. This session will help you to understand about changes and corrections. About changes and corrections. How flourishing the business may be, changes and corrections are part of it. Republic helps in making it a breeze. Change, add or remove a director, move to a new place, need to change the address? We're here to assist you in every step of it. Under changes and corrections have many services are there. 1. Company name change. 2. Registered office address change. 3. Add directors. 4. Remove directors. 5. Increase authorized capital. 6. Share transfer. 7. MOA and AO agreements. 8. Add partners. 9. Winding up of a company. 10. Winding up of an LLP. In changes and corrections, first service is company name change. The name of the company can be changed any time after it gets incorporated. A company can change its name if there is a change in its business, ownership, management, etc. Change company name will not have any impact on its existence. A company can change its name with the approval of shareholders in the general meeting and by making necessary filings with the Ministry of Corporate Affairs. Section governing the change company name. Section 13 read with Rule 29 of Companies, Incorporation, Rules, 2014. The company after incorporation can change company name by following way. Conversion of name from private to public, or conversion of name from public to private, or change of name from _limited to _limited. Change company name. Clause of the company involves alteration of Memorandum of Association, hereinafter referred to as Memorandum, of the company. Section 13 of Companies Act 2013 regulates the process of amendment in Memorandum of Association is applicable to all companies. For alteration in name clause of Memorandum of Association. Work to be done. Call and hold meeting of board director, fix day, date, time of extraordinary general meeting. Place draft notice of extraordinary general meeting before board. Call extraordinary general meeting, give at least 21 clear days notice of extraordinary general meeting along with explanatory statement through electronic mode or in writing to all the directors of company, all the members of company, auditor of company. What change in registered office of company? The registered office of a company is the main office of the company to which all communication relating to the company is sent by the governmental departments. The promoters of a company or LLP must declare the registered office of the company during incorporation and maintain certain mandatory documents at the registered office. Modes of change in registered office of company. Change in a situation of the registered office of the company may be required from time to time in any of the following manners. A. Change in registered office of company from one place to another place within the limits of the same city, town or village. B. Change in registered office to a place outside the local limits of the existing place but within the same state under the jurisdiction of the same registrar of companies. C. Change in registered office of company to a place from the jurisdiction of one registrar to that of another registrar within the same state. D. Change in registered office of company from one state to another state. A shifting of registered office within the local limit. 1. Section and rule applicable. Section 12 read with Rule 27 of Companies, Incorporation, Rules, 2014. 2. Nature of approval required. Board of Directors. 3. Process and work were done and forms to be filed. Board meeting place before board resolution of shifting of registered office for approval of directors to change in registered office of company. File form with ROC form incorporated 22 to be filed within 15 days of passing BR. B. Shifting the registered office outside the local limits of the existing place but in the same state. 1. Section and rule applicable. Section 12 read with Rule 27 of Companies, Incorporation, Rules, 2014. 2. Nature of approval required. Members' approval by means of special resolution. 3. Process and work were done and forms filed. Board meeting, place before board resolution of shifting of registered office for approval of directors to change in registered office of company. Fix date and time for EGM and place draft notice of extraordinary general meeting before board. Call and hold EGM, send notice for EGM and pass the special resolution at the EGM. File form with ROC and form incorporated 22 to be filed within 15 days of passing special resolution and file MGT 14 for special resolution. C. Shifting of the registered office from the jurisdiction of one registrar of the jurisdiction of another registrar within the same state. 1. Section and rule applicable. Section 12 read with Rule 28 of Companies, Incorporation, Rules, 2014. 2. Nature of approval required. Members' approval by means of special resolution and regional directorial TMS approval. 3. E-form to be filed and procedure to be followed. Board meeting, place before board resolution of shifting of registered office for approval of directors to change in registered office of company. Fix date and time for EGM and place the draft notice for the same. Hold EGM, pass special resolution at EGM for change in registered office. File application with ROD at least 21 days before filing any application with regional director. Publish a notice at least once in a daily newspaper and one English newspaper in which the registered office of the company is situated, and then application to ROD will be applied and then approved by ROD. File form with ROC form incorporated 22 to be filed within 15 days of passing special resolution. Also, file form MGT 14 to ROC for special resolution with all relevant attachment. Incorporated 23A with all required attachment within time frame. Incorporated 28 for file ROD order to ROC within time frame. D. Change in registered office of company from one state to another. 1. Section and rule applicable. Section 13 read with Rule 30 of Companies, Incorporation, Rules, 2014. 2. Nature of approval required. Member TMS approval by means of special resolution and regional director's approval. 3. E-form to be filed. Form purpose. MGT 14 for special resolution. GNL 1 for filing copy of application to ROC. Incorporated 23 for seeking approval of regional director. Incorporated 22 for shifting of registered office. Incorporated 28 for filing copy of ROD order with ROC. Time limit to file the form. Time limit within which the form has to be filed. Form purpose. MGT 14 within 30 days of passing special resolution. GNL 1 simultaneously with filing of form Incorporated 23. Incorporated 23 at least 1 month after serving notice to creditors and publication of newspaper advertisement. Incorporated 22 within 15 days of order passed by ROD. Incorporated 28 within 30 days of order passed by ROD. After completing of above mentions procedure, the registrar of the company will issue a certificate. Note: The shifting of registered office shall not be allowed if any inquiry, inspection or investigation has been started against the company or prosecution under the Act is pending. The change in registered office of company location shall be noted in the name board kept on the outside of every office of the company, its letterheads, business letters, bills of exchange and other documents where the registered office is mentioned. The time frame to complete the change of registered office. It takes approximately 25 days to 30 days for change in registered office. What is appointment of additional director? Director of a company is a person chosen by the shareholders for managing and looking after the affairs of the company according to the Memorandum of Association and Articles of Association of the company. As a company is an artificial legal person formed by law, it can only act through the group of natural persons. Thus, only living persons can be directors of a company and the management of a company is delegated to the board of directors. Appointment of directors may be required for a company from time to time as per the requirements of the shareholders of the business. To appoint a director, the person proposing to become a director must obtain or have a digital signature certificate, DSC, and director identification number, DIN, which is a mandatory requirement. Any person who is an Indian national or he is a non-resident Indian and any foreign nationals are allowed to obtain DIN and they can be appointed as director of a company in India. Types of director in a company to be appointed. Managing Director, Executive Director, Ordinary Director, Additional Director, Alternate Director. What is the procedure for adding a director? By passing an ordinary resolution at AGM or EGM as the case may be, a new director can be added to the board of directors. Ordinary resolutions can be passed by a simple majority. Once a resolution is passed, the company must file the resolution along with the necessary documents in the relevant forms and to the Ministry of Corporate Affairs to appoint a director. Document necessary and time were taken. Draft of board resolution and carry out necessary requirement relating the same and file the board resolution in relevant form with ROC. It takes approximately 6 to 8 working days once documents are received for the same and it will be done. What is the removal of a director? Section 169 of Companies Act 2013 deals with removal of director process. Introduction to remove a director. A company can only remove a director if he incurs any of the disqualifications specified under the Companies Act 2013. Section 169. Removal of directors. A company by passing an ordinary resolution remove a director, except to director appointed by the tribunal before the expiration of the term of his office after giving him a reasonable opportunity to be heard. Special notice will be obligatory of any kind of resolution to remove that director or to appoint someone or any person in place of such a director who is removed, at the meeting at which he is removed. Once the notice of a resolution to remove a director the company is received and then it shall send a copy to the director. File the relevant form with ROC to effect the removal of director of the company. Forms to be filed. File the DUR 12 with the ROC, Registrar of Companies to give effect for such a removal. Time taken. It takes approx. 5 working days once the documents are received from the client to complete the procedure for removal of the director. What is increase in authorized capital? Authorized capital is the amount of capital with which company is registered with Registrar of Companies. It is the maximum amount of capital up to which a company can raise fund through the issue of share. Companies generally are registered with small authorized capital and increase it eventually as per need. Authorized capital can be increased, only if it is authorized by Article of Association and after passing an ordinary resolution in the meeting of members. If increase is not authorized by AOA, appropriate steps to alter the article and include the clause is taken. Need to increase authorized capital of company. Authorized capital is the upper limit up to which a company can raise fund from public. In order to raise fund from public, you need to increase the authorized share capital of your company. Documents required for increasing authorized share capital. Memorandum of Association of the company. Article of Association of company. List of members, shareholders of company. Authorized capital proposed to be increased. Alteration of Article of Association of the company. Alteration of Memorandum of Association of company. Drafting of various resolutions. Filing of all the required forms with ROC. Procedure to increase authorized capital of a company. Check whether AOA of the company authorizes it to increase the authorized capital or not. If AOA is not authorized, you need to amend AOA by passing special resolution. Hold a board meeting and pass a resolution to increase the authorized capital of the company and decide day, date, time and place for extraordinary general meeting. Issue notice to every member, shareholder, director, auditor of the company specifying day, date, time, place and agenda of the meeting. Convene, hold and conduct EGM on the date, place and time specified, and pass a resolution to take approval from shareholders. File specified form if any, within a specified period. Alter Memorandum of Association of the company to increase the authorized share capital of the company. File Form SH7 with Registrar of Companies within 30 days of passing shareholders' resolution. Also, file Form MGT14 within 30 days of the passing of the resolution, if the resolution is passed as special resolution. Share transfer. The shares of a company can be transferred from one person to another by executing a share transfer deed. A private limited company is considered to be a closed corporation of members, similar to a partnership firm. Therefore, the share transfer in a private limited company can be restricted by the Articles of Association, AOA. Hence, the Articles of Association of the company must be reviewed prior to beginning the share transfer procedure. Restrictions on right of the shareholders to transfer shares are usually in two forms. Rights of preemption. If a shareholder wishes to sell some or all of his shares, such shares must first be offered to other existing members of the private limited company at a price determined by the directors or the auditor of the company. The value of the shares can be determined based on the formula, method prescribed in the Articles of Association. In no existing shareholder is interested, then shares of the company can be freely transferred to an outsider. Powers of directors to refuse. The director may have the powers to refuse registration of transfer of shares under certain circumstances, prescribed in the Articles of Association. Only restriction contained in the Articles of Association are considered legally binding. Any private agreement between the shareholders are not binding either on the company or on the shareholders. Further, share transfer can only be restricted by the Articles of Association. The right to transfer shares of a private limited company cannot be a total prohibition or ban on share transferability. Step 1. Review the AOA. Articles of Association of the private limited company must be reviewed and restrictions, if any, must be addressed. Step 2. Shareholder must give notice in writing to the director of the company about intention to transfer share of the company. Step 3. Determine the price as per Articles of Association at which the shares of the company will first be offered to present shareholders of the company. Usually this price is determined by the directors of the company or an auditor of the company. Step 4. The company must then give notice to the other shareholders about the availability of share, the last date to purchase the shares and the price at which the shares are available. If how to transfer shares of a private limited company. To effect the share transfer, the following steps must be followed. Step 1. Obtain share transfer deed in the prescribed format. Step 2. Execute the share transfer deed duly signed by the transferor and transferee. Step 3. Stamp the share transfer deed as per the Indian Stamp Act and stamp duty notification in force in the state. Step 4. Have a witness sign the share transfer deed with his/her signature, name and address. Step 5. Attach the share certificate or allotment letter with the transfer deed and deliver the same to the company. Step 6. The company must process the documents and, if approved, issue new share certificate in the name of the transferee. Let's understand about Memorandum of Articles and Article of Association. The Memorandum of Association of a company must be changed whenever there are changes to the object, situation or capital or liability of a company. Memorandum of Association of a company sets down the constitution of a company including the permitted range of activities of the company, state of incorporation, type of company, capital clause, liability clause and more. Changes to Memorandum of Association of a company can be required. Changes to Memorandum of Association, MOA, can be effected through a special resolution at the shareholders' meeting. Changing the MOA of a company is a complex and extensive procedure, hence due professional care must be taken during the procedure. In this article, we look at the various reasons for effecting changes to MOA of a company. Alteration of name in MOA. Changes to the name of a company would require an alteration to the MOA by passing a special resolution. In case changes to the name of a private limited or public limited company is affected, consent or authorization of central government is not required. In any other case, the consent of central government would be required. Further, in the event of a company being registered with a name that bears a resemblance to a name of an existing company, the central government might ask it to alter its name. In such a case, ordinary resolution is adequate. Change of registered office, state to state. A company must make changes to the MOA for transfer of registered office from one state to another. Usual reasons for changing registered office from one state to another include: to conduct business more professionally and economically, to attain the significant purpose of the company by sophisticated means, to develop its operations in the current location, to manage any of the existing objects, to sell a whole or part of the business enterprise, to merge with other business or person. In the event of registered office has to be shifted from one state to another state, a special resolution has to be approved and approval from the company law board has to be acquired by the company. The changed memorandum must be filed with the registrar of the state from which the company is changing and also to the registrar of the state to which the company is shifted. On approval of the Registrar of Companies, ROC, changes must be made in the MOA of the company to reflect the new state where the registered office is situated. Alteration of Objects Clause. Changes to the object clause of a private limited company can be effected easily with minimal hassles. However, changing the objects of a company that has raised money from public will require a special resolution. Further, the special resolution must be published in newspapers both in English and another in local language which are in circulation at place where the registered office of the company is located. The details should also be displayed on the company's website, if any, along with the justification for modification in objects of the company. Finally, all dissenting shareholders should be given an opportunity to exit by the promoters and shareholders possessing control of the company. This opportunity must be given in accordance with regulations specified by the Securities and Exchange Board of India, SEBI. Alteration of Liability Clause. The liability clause can be changed so as to make the liability of the directors unlimited. In any case, the liability of the shareholder cannot be made unlimited. The liability clause can be modified by passing a special resolution. A copy of the resolution should be filed with the registrar within a period of 30 days. Alteration of capital clause. A company can change its capital clause by the passing of an ordinary resolution in a general meeting. Alteration of capital may relate to subdivision of the shares, consolidation of the shares, conversion of shares into stock and annulment of unsubscribed capital. Within a period of 30 days of passing a resolution, the altered articles and memorandum have to be submitted to the registrar. Alteration of authorized capital. A company looking for the issue shares must check the current authorized capital of the company, as the issue cannot be in excess of the amount of authorized capital. Therefore, in the view of the above, a company may have to increase the authorized capital and make modifications to the MO of the company. Articles of Association, an overview. Articles of Association is a document which prescribes the rules and bylaws for the general management of the company and for the attainment of its object as given in the memorandum. It is a document of paramount significance in the life of a company as it contains the regulations for the internal administration of the company's affairs. The Articles of Association are a subsidiary to the Memorandum of Association of the company. They define the rights, duties, powers of the management of a company as between themselves and the company at large. Further, they also prescribe the mode and form in which changes in the internal regulation of a company may be made from time to time. The Articles of Association of a company must always be in consonance with the memorandum of that company and being subordinate to the memorandum. They cannot extend the objects of a company as specified in the memorandum of the company. Meaning of Articles of Association. The Articles of Association can be seen as a rule book within a company. This is in a document form and is a part of the company's constitution alongside the memorandum. This document contains internal detailed governing aspects of the company's organization. These include shares, issue and rights attached to them, the conduct of the company meetings and the role and powers of the directors. The articles detail rules which govern the conduct of directors, the rights of the shareholders and the relationship between the two. Importance of Articles of Association. Under Section 36, the memorandum and the articles when registered, shall bind the company and its members to the same extent as if it had been signed by them and had contained a covenant on their part that the memorandum and the articles shall be observed. With respect to the above section, the importance of Articles of Association can be summed up as follows. 1. Binding on members in their relation to the company. The members are bound to the company by the provisions of the articles just as much as if they had all put their seals to them. 2. Binding on company in relation to its members just as members are bound to the company. The company is bound to the members to observe and follow the articles. 3. Neither company nor members bound to outsiders. Articles bind the members to the company and company to the members, but neither of them is bound to an outsider to give effect to the articles. 4. Binding between members inter se. The articles define rights and liabilities of the members. As between members inter se, the articles constitute a contract between them and are also binding on each member as against the other or others. Such contract can be enforced only through the medium of the company. Contents of the Articles of Association : Each limited liability company must have Articles of Association. They are the company's internal regulations, which bind the company, its administrative bodies, management and auditors. The Articles of Association must be complied with in the same manner as the Limited Liability Companies Act. Include provisions regarding the following. 1. Company name. The company name of a private limited liability company must include the words, if the company intends to use its company name in 2 or more languages, the names in other languages must be stated in the Articles of Association. 2. A Finnish municipality as the company's place of business. A company may practice its activities in several places and also abroad, but its registered place of business can only be in one Finnish municipality. 3. The company's field of activity. The term field of activity refers to the fields in which the company carries on its business activity. Any activity, which may be pursued legally in the form of a limited liability company, can constitute the company's field of activity. A company can have several fields of activity, but they must all be registered, although legislation is silent about how precise the definition of the field of activity needs to be. Inexact and unnecessarily extensive definitions should be avoided. 4. Share capital. The share capital can be stated either as a fixed amount or as minimum and maximum amounts. In case the share capital has been defined as minimum and maximum capital, it can be increased and decreased within these limits without a need to amend the Articles of Association. 5. Nominal value and number of shares. If the nominal value is defined in the Articles of Association, all shares must have the same nominal value. 7. Notice of a general meeting of shareholders. The Articles of Association may stipulate the manner in which and when the notice to the annual general meeting of shareholders must be given. The notice may be given e.g. by announcement in a newspaper or by a written notice delivered to the persons who have been entered in the share and shareholders registers. 8. The agenda of the annual general meeting. The Articles of Association may state the agenda of the annual general meeting. Matters, which according to mandatory law provisions must be considered at the annual general meeting, shall also be included on the agenda. 9. Accounting period of the company. According to the Auditing Act, the accounting period of the company may be a calendar year or any other period of 12 months. 10. Supplementary provisions. The Limited Liability Companies Act provides several legal alternatives, the use of which requires supplementary provisions to be inserted into the Articles of Association. 11. Other provisions. In addition to mandatory provisions, the shareholders may also quite freely include other provisions in the Articles of Association. The other provisions may not, however, contradict the mandatory. Add partner. Every LLP shall have at least 2 designated partners, at least one of which must be resident in India. To add a new partner to existing LLP, consent of all partners is required. However, if the LLP agreement allows that one partner can add new partner without the consent of other partners, then the consent of all partners is not required. Procedure for appointment of designated partner to LLP. A designated partner can be appointment to an existing LLP with the consent of all existing partners of LLP as per the provisions of Section 25 of LLP Act, 2008. Liabilities of proposed designated partner. Rights and liabilities of proposed designated partner will be decided to by the LLP agreement entered by the existing partners of the LLP. Existing partners. After getting the consent of existing partners for admission of a proposed designated partner in a duly convened meeting, a supplementary LLP agreement needs to be drafted and filed with Registrar of Companies. Consent of proposed designated partner is also required to be obtained from him/her in the prescribed form. After the appointment, it is required by the LLP to intimate concerned Registrar of Companies about the change in e-form LLP4 after getting it certified by practicing CA/CS/CMA within 30 days of appointment. Supplementary LLP agreement is also required to be filed with the concerned Registrar of Companies in e-form LLP3 within 30 days of the appointment of designated partner. General duties. Partners of a LLP are bound to carry on the business of the LLP to common advantage, to be just and faithful to each other, and to render true accounts and full information of all things affecting the firm to any partner. Duty to indemnify. Every partner of a LLP is required to indemnify the LLP for any losses caused to it by a fraud in the conduct of the business of the firm. Implied authority. The authority of a partner to bind the LLP, in case of a transaction carried on, in the usual way business is carried on by the LLP, binds the LLP. Rights of partner. All partners have right to take part in the conduct of the business of the LLP and access to inspect and copy the book of accounts of the LLP. Documents required for appointment of designated partner to LLP. Copy of Aadhaar card of proposed designated partner. Copy of PAN card. Passport-sized photograph. Scanned copy of signature. Existing LLP agreement. Winding up a private limited company. Winding up a private limited company is a tedious, but necessary, procedure. Without doing so, you would need to annually meet the requirements of the Registrar of Companies, which means spending money on audit and compliances. The bigger reason you would want to do this, of course, is because it releases the assets and investments made by you. What it includes. 1. Public accountant. A public accountant would be appointed by the court as a liquidator. The powers of the directors would devolve upon this person and he would be mainly responsible for accumulating all the assets of the company and paying off its debts. The excess would then be disseminated amongst the members. 2. Documents required. A statement of account has to be prepared, stating that there are no assets and liabilities except share capital and profit and loss debit balance. An affidavit and indemnity needs to be executed by all directors. If there is any unsecured loan, a waiver letter should be submitted. Procedure for winding up. Depending upon the type of industry, the following elements are central to the drafting of vendor agreements. Approx. 30 working days. The statement of accounts must be submitted no more than a month before submission of the application. This is a declaration to the ROC that only what is submitted is to be considered and that the company has no other assets or liabilities. Approx. 25 working days. Within a month of the submission of the statement of accounts, the application must be submitted along with the documents mentioned above. Approx. 3 months. It takes at least 2 to 3 months to complete the closure of your company, but it could take much longer, depending on the findings of the liquidator appointed. Wind up an LLP. LLP or limited liability partnership is a partnership wherein all the members, partners, have limited liabilities. Normally, an LLP is set up in legal terms and documents and policies. The LLP Act, 2008 also offers certain essential procedures for closure of an LLP. Any LLP can close down its business by adhering or implementing any of the following 2 ways. 1. Declaring the LLP as defunct. 2. Winding up of LLP. Declaring the LLP as defunct. In case the LLP wants to wrap up its business or where it is not carrying on any business operations, it can make an application to the Registrar of Companies, ROC, for announcing the company as defunct and eliminating the name of the LLP from its list of LLP. E-Form 24 is obligatory to be filed with ROC for striking off the name of LLP. Similarly, Registrar also has the power to strike off any defunct LLP only after satisfying himself the need to strike off and has a real reason, though, in such cases, the Registrar has to send a notice to the LLP of his intent and request to send their representation within 1 month from the date of such notice. The ROC Registrar shall also publish on its website such a notice or content of the application made by the LLP for a period of 1 month for the info of the general public. If there is no reply received within the stated period by the Registrar from LLP, then the Registrar may strike off the name of LLP from its register. Winding up of LLP. Winding up is a process wherein all the assets of the business are disposed of for the reason to meet the liabilities of the same, and after the liabilities are met and after if surplus any remains, it is distributed among the owners. The LLP Act 2008 provides for following 2 methods for winding up the LLP, i.e. 1. Voluntary winding up. 2. Compulsory winding up. Involuntary winding up. The partners may among themselves choose to wound up the operations of the LLP. In compulsory winding up, limited liability partnership will be compulsorily be wound up by the tribunal. Limited liability partnership will be compulsorily be wound up by the tribunal. If the limited liability partnership, LLP, chooses that limited liability partnership should be wound up by the tribunal for a tenure of more than 6 months, the numbers of partners of the limited liability partnership is reduced below 2. If the limited liability partnership LLP is incapable to pay off its outstanding debts. If the LLP, limited liability partnership has acted against the interests of the sovereignty and integrity of India and also acted against the security of the state or public order. If the limited liability partnership, LLP, has made a defaulting in filing with the ROC or registrar the statement of account and solvency or annual return which is mandatory compliance for any 5 consecutive financial years. If the tribunal is of the opinion that it is just and equitable that the limited liability partnership is wound up. Procedure for winding up. 1. Day's work done. File Form 24 with the ROC along with the declaration from the partners. 2. Approximately 4 working days. Along with the main application, also submit indemnity bonds and affidavits stating that the information is true to the knowledge of all the partners. Approximately 20 working days the registrar will publish a notice on its website containing the substance of the application for a period of 1 month. Approximately 10 working days after 1 month, the registrar will remove your LLP's name from the register and publish a notice in the official gazette, thereby legally dissolve the LLP.